Good afternoon, everyone. Welcome to our February 12th webinar, HOA attorneys. How do you best use them and save on legal fees? Something that's very near and dear to my heart, probably near and dear to your hearts as well, because everybody is always trying to save on legal fees. My name is Elena Gilbert. I will be presenting the webinar today. We're going to go through a few housekeeping items. First, meanwhile, enjoy the meme. I always like this one. But on the screen, for those of you who haven't done this before, the bulk of your screen really should be this PowerPoint. And on the left side is me, the presenter. Hello. And on the right side, you will see a little icon that says chat. So you will click on that. If you have questions, you can type them in there and we will go through any questions at the end of the presentation. We will probably have lots of extra time at the end to go through your questions. I don't know if you will have any questions, but if you do, go ahead and type them in and we will go through them at the end. Let's see. If you are having any audio or video problems, there is a little button at the bottom that says no audio or video question mark. Go ahead and click on that and it'll take you through a few steps and hopefully resolve whatever problems you are having. You will get 1 CMCA credit for attending today. It will be automatically generated and emailed over to you either today or tomorrow. It is you know, they're generated really weird now. It's actually part of the email and you have to make sure you save the image right away because now apparently they go away after like a day or two. So just please be very diligent once you get that email. Either print out your certificate or like save the image, do something with it so it doesn't just disappear later on. If you're having any problems with your certificate, please just email education@altitude.law, okay? And we will make sure and get that addressed for you. As a quick reminder, this class will be recorded and it's going to go on our YouTube channel. So if you are talking to someone who says, gee, I wish I could see this, but I couldn't make it to the webinar, just let them know it's going to be on the YouTube channel. Probably in the next couple of days, it's going to get posted. So they are welcome to watch it. They just cannot get CMCA credits for it. And then finally, there will be a survey that pops up at the very end of this presentation. If you have the time and the inclination, please, please, please respond to it. We always look at the responses. We take them seriously. We really appreciate any feedback you could provide. There's no such thing as bad feedback as far as I'm concerned. It's feedback and it helps us improve these classes in the future. So please, if you can spare the time, please provide us with whatever comments you might have. All right, so without further ado, you will notice a lot of these memes. I'm actually picking on the attorneys, which I don't get to do very often, so enjoy them. I know you all do it behind our backs anyway, and a lot of times to our faces. So what do HOA attorneys do really to earn their keep? What do we do for you? Well, this is just a list. It's a generic list, and I know there's a lot more on that list. There were just things that I came up with thinking just the last few weeks of what I've done for associations. You know, we give you legal opinions on different things. We review your contracts. We interpret your documents. We attend meetings, do collections for you, covenant enforcement, litigation, and just a general smorgasbord of whatever happens to come up. This is actually really why I love practicing law in this area, is because it's never the same day twice. And just when you think you've seen it all, boom, there it is, something completely different. So it really is, you practice in all areas as far as I'm concerned when it comes to HOAs. You just never know what's going to come up. And as HOA community managers and board members, it's very similar for you guys as well, because you may think you've seen it all, but then something happens or you get an email and you're like, well, I've never encountered that before. What do I do with this, right? And so we're always learning, we're always coming across new situations, and we need to figure out how to handle those. And a lot of times associations need to engage the HOA attorneys to help them figure out how to move forward with something. And that is absolutely appropriate. But oftentimes when we engage attorneys, the boards end up getting these bills and they're not really sure how they got to thousands of dollars in legal fees for what they perceive to be a relatively simple thing. And so the purpose of really today's presentation is I want to just dive into a little bit as to where things go wrong in communicating between the clients and the attorneys, and also how to actually use your attorneys effectively so you aren't racking up a whole bunch of legal fees. And you're probably thinking, Alina, what's in this for you? Why on earth would you be teaching a class teaching us how to spend less money on you? Well, honestly, it is a little bit self-serving for me as well, because a lot of things that clients spend money on for us is really things that wastes our time as well, where we could be billing for other things. But instead, we're just sitting there waiting for things to happen. So it really is a benefit to both us as attorneys and to you as far as saving on legal fees. So yes, there is some benefit to me as well in teaching this class. Before we talk about all that, I want to talk a little bit about how association attorneys bill, and really all attorneys. There's going to be three primary methods that your communities get billed. We get billed, you get billed using a flat fee, hourly rates, and then there's retainer services. So first of all, you should know at any given moment how your association is getting charged by your legal counsel. A flat fee means the attorney is going to do a project for you and they are going to charge you a lump sum dollar amount for that project. It doesn't matter how many hours they spend. So for example, I am going to prepare a policy for you. I can spend 2 minutes on the policy, or I can spend 10 hours on the policy. You're going to get charged exactly the same dollar amount. Okay, so the benefit to the client is the client knows exactly how much it's going to cost them, and they don't have to worry about whether or not the attorney is going to take a long time to draft it or not. And that is a great way to go. Flat fees are always good for the clients, but here's where things go wrong. You as a client need to understand that not necessarily every little thing is included in the flat fee. And so at some point, it might go to an hourly rate. And you need to understand what exactly is included in the flat fee and what is not included in the flat fee. And we're going to talk about that in a lot more detail later on. But one big mistake that we'll see clients make is they say, oh, this is a flat fee. That means anything and everything is going to be included in this flat fee. And I can call the attorney as much as I want. I can ask for 10,000 revisions. I can do 5,000 emails, and it's all part of the $300 flat fee. It's not. So keep that in mind with flat fees. Hourly rates. Hourly rates are exactly that. You get charged by every single minute, right? Every minute is going to count. So that means every email, however long it takes your attorney to respond to an email, however long that attorney stays on the phone with you, however long it takes that attorney to look through your governing documents and then type an email responding to your questions, that's how you're going to get billed. So make sure you also know your attorney's hourly rates then, right? Because if it's hourly, it's however long it took times their hourly rate. So how do attorneys bill hourly? How do they calculate that? I mean, usually your it's going to be like on a 0.1, 0.2, 0.3 basis, which is really every 6 minutes, because you can't really divide it too much more than that. So just kind of keep in mind that every 6 minutes is an increment, and so that's really how often you're getting another little notch of billing. So again, if you're being billed hourly, keep track of every minute that you're talking to your attorney. Then there's retainer services. I am pretty sure that most HOA firms offer some sort of a retainer service. I know they're all a little bit different, so I can't speak for, what specifics, are in each firm's retainer, but you should understand when you sign up for a retainer with a specific firm, what is covered by that retainer, and of course, what isn't covered by that retainer. Just by way of example, Altitude has 3 levels of retainer. Some of them include emails, some of them don't. Some of them include attendance at 1 meeting per year. Some of them include 2 meetings per year, up to an hour. So you need to know when you are on a retainer, what portion of it is covered by the retainer and what portion is not. Being aware of these things is the first step in not getting any surprises on your legal invoices. All right. And now I want to talk about some best practices with respect to how you actually use your attorney's time. I'm not going to tell you, how to have them write an opinion letter for you, but I want to talk a little bit about what you do with your attorneys while they are doing things for you. So for example, while your attorney is at a meeting, and it could be a board meeting, it could be a homeowners meeting, it really doesn't matter. I think the first thing is know why you have the attorney at the meeting. Sometimes your attorney is there just to answer one question or discuss one topic with the board. Sometimes the attorney is there to answer questions from homeowners about one specific issue. Sometimes you actually want your attorney there the whole time. Sometimes you want your attorney there just for open forum. Know why you have your attorney there. Also, I didn't put this in here, but know how your attorney is billing for that meeting. If your attorney is billing hourly, every minute is counting, so don't start late. Because again, if you're paying your attorney to sit there and twiddle their thumbs, waiting for the meeting to start, you're wasting money. You're wasting the association's money. You're basically having that attorney sit there, provide no legal services to the association, but you're paying for it. So don't do that. Another thought is have your attorney attend virtually if at all possible instead of in person. Some firms charge driving time. So to save on legal fees for your attorney to drive to the meeting, you might be better served having that individual attend virtually. Is there anything that you need the attorney there for in person? Are you wanting them to step in front of the board and take bullets? Are you wanting them there in case somebody throws tomatoes so they can take the hit for you? Okay, then pay for the driving time. But ultimately, think about the purpose, again, of why the attorney is there and whether or not they need to be there in person. And if they really do need to be there in person, that's fine. I'm sure attorneys are happy to go in person. Just also be aware of whether or not you're going to get charged for driving time, because that could significantly increase the total fees. Okay. Don't have the attorney wait while you're doing check-in. I have been to many a meeting, both in person and virtually, where the board's like, get here at 6. Well, I get there at 6 and there's check-in, and check-in goes for another 40 minutes, and the meeting doesn't start until after that. And I just sat there for 40 minutes charging my association to sit there. So it goes hand in hand with not starting late. Don't pay your attorney to be there while you're doing check-in. It wastes your attorney's time, which I said it doesn't behoove the attorney to be there, and it certainly wastes your money. Don't have your attorney sit through the homeowner forum if that's not the purpose of the attorney's attendance. So for example, if your attorney is there to talk about a document amendment that's about to get proposed to the homeowners, postpone the homeowner forum. Let it go after the attorney does his or her spiel on the document amendment. Because otherwise, you guys know how homeowner forums are, right? They never last the 20 minutes you budget. They're always going to go longer. There's always going to be something to say. So why waste your money to have the attorney wait? Get the attorney in and out of that meeting so you can stop bleeding legal fees. I've had the question of, well, what if the attorney is there and they're on retainer? Then it really doesn't matter, right? Maybe, but most retainers, you have a time limit on how long the attorney can be there for. Usually it's an hour. So if your attorney's only there for an hour, then the clock starts ticking after that hour. And also with a retainer, you might still be getting charged drive time. So that's important to understand. So make sure you're aware of all the circumstances. But also, speaking as one of the pitiful attorneys, be kind to your attorney. We really don't like sitting there just, waiting to be put on. It's kind of a waste of our time as well. So to the extent you have any empathy for us, please, please, please tell us to come there when it's our turn to speak, or put us on at the very beginning. More stuff on meetings. Have the attorney go first, like I was just saying. It's just cleaner and easier. Do not have board conversations about non-legal issues while the attorney is at the meeting and billing you. So this is really more for board meetings. I have been to a lot of board meetings where I am there, for example, to talk about maintenance issues, and I am talking to the board about repaving the parking lot. All of a sudden, the board goes off on a tangent and they want to talk about parking rules. Well, if we repave, then do we want to move around, where people can park, and should we reassign parking? And they go off on a tangent for about 45 minutes. They're talking about whether or not they want to redo their parking rules, which really has nothing to do with the topic of why I showed up. And I sit there and I listen to them, but they're getting charged for me to sit there and do nothing except listen to them. So again, this happens very, very often. And I don't know that boards realize a lot of times, one, that they're going off topic, and two, that they're paying an attorney to sit there while they're going off on a tangent. So be very mindful of that, because you're wasting money when you do that, okay? And as community managers, as senior board members, and even as the attorney at the meeting, I will eventually say, hey, do you guys need me for anything else that's legal in nature? Because I hate for you to keep paying me to be here if you don't need me, So it's just be mindful of that. You can save money that way. Again, dismiss your attorney as soon as he or she is done. So those are kind of best use recommendations at meetings. All right, how about some phone calls? Let's talk about phone calls. I love that meme. Legal advice, $5. Accurate legal advice, $5,000. It's true. It's true. Good attorneys cost more. All right, phone calls. The best case scenario is getting all your legal issues addressed in one phone call instead of multiple phone calls. You're always going to pay more for multiple phone calls than you are for one phone call, even if it's one longer phone call. So what can you do to try and get everything done in one call? A one and done, so to speak. Well, you can prepare a list. I actually have several board members who, when I talk to them, I know it's going to be a long phone call because they have a list They have a list of specific things they want to discuss, and they're very thorough. So I know it's going to be a long call, but then I know I'm not going to hear from them for quite a while because we've just gone through everything and answered all their questions. And that actually costs them less than if they called me for one question, then called me tomorrow for another, and then called me for a third, a fourth, a fifth. So try to prepare a list if you've got several issues that you want to talk about, and try to eliminate the need for these multiple calls because you will save money that way. And make sure when you are calling the attorney that you actually have all the information. No matter really how little the piece of information is, as long as it pertains to the situation, it could change the opinion. So I had a situation a couple weeks ago, actually, where I got an email from a manager, and it was basically who has the duty to repair this component inside a unit that got damaged with water intrusion. And I said, well, I looked at their documents. I said, technically, this component is supposed to be maintained and repaired by the homeowner, but I don't really know what happened there. And, I need more information as far as kind of how it was damaged, what happened, blah, blah, blah. Well, I didn't hear back. And then I got an email about a week later from a board member saying, well, here's some more information on this situation. Well, that completely changed the answer to that question because it was information that really changed the scope of what had happened. There was some negligence issues. There were some other things going on in there. And I said, well, that's really going to change the answer. And then the board was really unhappy about that. They said, well, what do you mean? You already said X. And I said, yes, but if you know, I said X, but I also said that additional information could change the result. So you're going to be wasting money if you don't provide your attorneys with all the information, because if they get more information later on, they're going to need to redo the analysis, and they may need to change their opinion, and you've just spent probably twice as much money for them to do the opinion twice, because now they've gotten different information than what they originally had. So try to get as much information as you possibly can up front to your counsel before they render any kind of an, opinion, whether it's on the phone or whether it's in writing. And don't waste time discussing irrelevant issues. Now, I just told you to get them all the information, and I'm saying don't waste time with irrelevant issues. How do you know what's irrelevant? Well, what I mean by irrelevant is something that really has nothing to do with the situation at hand. Like sometimes I will be talking to someone and they get into personality issues with board members. Well, but this person really doesn't like this person, and this person, they're a horrible board member. And then this person, well, let me tell you, they used to be on the board and then they got off the board and they went back on the board. Well, none of it has to do with the situation at hand. And although, political information sometimes is useful, a lot of times it's just not important. So be mindful also of what you are providing and try to not go off on tangents. Emails. All right. So this is going to be very similar to the phone calls and the meetings. As you can see, there's a pattern here. Try to get all the information in one email. Every follow-up question costs money. The back and forth exchanges cost money. Now, even if you're on a retainer program that covers emails, I can pretty much assure you it's not going to cover all your emails. There's a limit to how many emails it covers. And emails add up very quickly when there's a lot of follow-up and back and forth. So if you're on a retainer, make sure you know how many of your emails are covered. And if you're not on retainer, just know that every email costs you. If there's a lot of things to discuss, sometimes a phone call would actually be quicker and cheaper. I can tell you a lot more stuff like this than if I was typing it all out, right? If I had to type out everything I'm telling you right now during this class, it's going to take me a lot longer than an hour to type it all out. I talk faster than I type. I talk clearer, and actually, you know, if we were having a face-to-face or a phone conversation, you would be able to interject your questions immediately, and we could clarify any confusion right there and then. So keep in mind that sometimes we've gotten away from the phone, but sometimes the phone call is easier, it's quicker, and it's cheaper, especially if you have some sort of a retainer program where phone calls are covered. Finally, for the same reasons we already talked about, make sure you provide all the information to your attorneys in the email, in the phone call, wherever. We don't want to have attorneys following up with you because it costs money. Every time the attorney reaches out to you, it's going to cost money. So it all adds up. Okay. All right, now comes the fun part. This is where we talk about where did things go wrong. By the way, do you guys like this meme? It's hilarious. I don't know if I'm the only dork laughing at these, but I think they're hilarious. Where do things go wrong? All right, let's talk about some common mistakes. These are the real life examples of what I have seen personally. Assumption that quick emails and phone calls are not charged. So I get emails like, the bylaws require 3 directors, but we have 5. Can we amend the bylaws without homeowner approval? I can respond and say, well, the Nonprofit Act says that you can unless your bylaws specifically prohibit it. It's a fairly quick email. Well, I'm going to charge a 0.2 for that. Okay, so you're going to get a bill. It's going to be like $78. I have had both board members and managers calling our accounting, Kevin, saying, what is this $78? I don't understand. It was a quick question. Why did we get charged for this? Okay, well, quick questions are still use of legal services. And I am almost positive that none of us want to work without being compensated, right? We all get compensated in different ways. Well, whether it's a quick legal service or a really lengthy one, we still need to get compensated, right? That's how our businesses work. That's how we stay in business. So whether it's a quick email or a quick call or not, I mean, your association should expect to get a charge. Assumptions that general inquiries are free. Oh, I cannot tell you how many times that has happened where a board member, it's usually a board member, and sometimes it's like after a class, right? They will send an email and they'll say, hey, I'm the board president for this and this community. You are our legal counsel. And so what happens if we decide we want to remove board member X from the board? What do our documents require? And then we'll go in, we'll look at the documents, and we'll respond and say, okay, so according to your documents, you need to do blah, 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 blah to do this. And then they get a bill for that email and they're shocked. It was a general inquiry. This was from the class. Well, no, it wasn't. You wanted us to look at your documents and provide you a step-by-step on how to do things. These things are not free. If you think they should be free, then at least put in the email, hey, is this free? Because if it's not free, don't do it. And then you'll probably get a response saying, I'm sorry, unfortunately, we would have to charge for that. And so tell us if you want us to do it at some point. But, don't ever, the rule of thumb is don't assume it's free, because almost everything gets charged. Now, what is free, I'll tell you what is free. Yes or no answers. Hey, Alina, are you available to come to a meeting? Sure, I am. I mean, scheduling things are free. You shouldn't ever be charged to schedule meetings or phone calls. You shouldn't be charged if we screwed something up and you're like, hey, Alina, you screwed up this letter. You misspelled this thing, and I'm like, I'll fix it for you. Shouldn't be charged for anything like that. But if we're giving legal advice and we're explaining how to do something, or reviewing something, that's not generally going to be free, okay? Board's assumption that a director cannot request legal work from an attorney. So this is a situation where you have a board that doesn't get along, and we've got feuding board members, and one board member reaches out to our office and says, hey, can you get me an opinion on board members' fiduciary duty to do X? We have no idea what's going on between the board. We have a legal obligation to provide services to the association, that is represented by its board of directors and the community manager. So anytime a community manager or any director reaches out to us and asks us to do something for the association, we rely on that, and we are legally entitled to rely on that because these are legal representatives of the association. Well, sometimes these people ask us to do something and the rest of the board has no clue that we've been asked to do this, and then they get a bill for it and they're not happy, and I don't blame them for being unhappy. But the way to address those types of situations is send an email to our office or to your attorney's office, whoever that is, and say, we are only allowing one person or two people or whatever to have communications with you and your office and to ask for legal work. And those people are this person and this person. And you are not allowed to talk to or incur legal fees from anyone else on the board. Send that to us, send that to your association attorney, copy the rest of the board so we know it's legit. And then guess what? If we take on legal work from someone else, that's on us, because you've told us that we can only take work from this one person or these two people. That's how you address that type of a situation. But unless we're instructed to only accept legal work from one or two people on the board, we are legally entitled to rely on any board member or community manager who requests a project from us. We have to produce it then. Okay, so be careful with those things. And if you are having those kinds of issues on your boards, then make sure you notify legal counsel as to who is authorized to direct any kind of work. All right. Assumption that all follow-up questions by email and phone call are included in a flat fee. So remember earlier I said, make sure you know if the project is a flat fee. So, as I also said, a lot of times clients assume that the flat fee covers everything. So, for example, we prepare an updated collections policy for the association, and we charge you whatever, a flat fee of $300. I'm not saying it's, well, you know, a nice round number, $300. And then the board decides it's going to send us 50 emails with very specific questions. Well, where in the declaration does it say this? How come you wrote this? We want this changed to this. And I mean, and basically each email, and I've had this happen, takes about 30 minutes to respond to. Association gets a bill for that. How dare you charge us for these emails, Alina, when we had a flat fee? So I direct them to the flat fee agreement that we send out that says, this flat fee includes minor revisions and short responses to a few questions. Anything beyond that is hourly. You should never assume that a flat fee includes anything and everything after the project has been sent over to the client. It does not. We would be stupid to say it includes anything and everything. And I don't understand why some boards think it does. I mean, how dumb would I be to say, yeah, it's $300, but we're going to spend another, 20 hours answering your questions and rewriting everything at no charge to you. It's just not going to happen. We'd go bankrupt if we did that. So make sure, like I said, your clients and you understand that what the flat fee encompasses and what it does not encompass, because you're not going to get unlimited follow-up emails or phone calls on a specific thing, when it's a flat fee. Again, same thing, assumption that all revisions are included in a flat fee. That is also not going to be the case. Usually it's several minor revisions. If the board wants a complete full overhaul rewrite, that is not something that is typically going to be included in the flat fee. Okay. Assumptions that emails are covered by retainer. So I get calls and questions at least once a week. Do I get a question from usually a board member, sometimes managers, saying, I got charged for an email, but we're on retainer. And I said, well, yeah, but you're in a retainer program that doesn't cover emails. We are? I thought all retainers cover email. No, they don't. So again, that's an assumption that people make without actually reading the description of the retainer. So please make sure that your boards and that you as community managers are reading these agreements from our office, from other attorneys' offices, because they should be really spelling out for your boards what's going to be included and what's not going to be included. And it's so important that boards understand what's not included, then they won't have surprises. And they might then also consider or reconsider how they communicate with their attorneys, when they communicate, and how long they want to keep someone on the phone, for that matter. Okay, and then finally, of course, the assumption that everything is covered by the retainer. I have conversations all the time where I will talk to someone, they'll be like, so we need you to review this contract, and this is covered by retainer, right? No. So at least they ask usually, and it doesn't hurt to ask, but not everything is covered by the retainer. So again, please make sure your boards are aware of this. Okay, next. All right, this is a big one. Trying to save money by not having attorneys review contracts. I get it. Money is really tight right now for associations. We've got insurance rates that are skyrocketing, and associations are barely holding it together. We're seeing special assessments. We're seeing huge assessment increases. It is very difficult right now for communities to make ends meet, and I do get it. But I don't want you losing more money than what you're going to spend by having your contracts reviewed. I just had a situation, and this is not uncommon. I just got contacted by a manager who said, my association, they want to get out of this contract because this contractor isn't doing a good job and they're overcharging my association for these services. Well, I said, okay, let me look at the contract. They didn't have us review the contract up front, so it was never reviewed by any attorney. And the way it was drafted was, yes, you can terminate the contract, so there's at least that, but it doesn't allow the association to withhold payment. It doesn't allow the association to terminate immediately. It doesn't allow anything for cause. It doesn't even really allow, the association can't even go after the contractor for the money. The contractor has full discretion on everything. It is a contract that this association, they're not going to be able to get their money back. They're going to have to pay this contractor who unreasonably charged them, but they're not going to be able to do anything about that. Now, if an attorney reviewed this contract, would it have been drafted differently? Probably. Is this association now going to be out of pocket money that it shouldn't have been? Probably. Would it have cost less money for an attorney to review the contract and negotiated than what now it's going to have to pay the contractor? Probably. So these are the types of situations that we see over and over and over again. So when we say make sure your attorney reviews the contract, we're not saying it because we want to make money off these associations. We're saying it because you're going to save money in the long run should there be any issues down the road. And it's a time-proven thing. Now, I would say any contract over $10,000, absolutely positively have it reviewed by legal counsel. I mean, figure out how to do it and get it done, get it reviewed by legal counsel. In better economic days for associations, I would recommend $5,000 and over gets reviewed by counsel. A contract review typically costs anywhere like between $1,000 to $2,000, depending on the complexity of a contract, I would think. So do the math. But right now, anything over $10,000, I would highly, highly recommend having associations kind of take that leap of faith and have it reviewed, because you will save money in the long run if anything goes wrong with that contract. Next, trying to save money by not asking for a legal opinion. Well, as it says here, it costs more money to fix a problem than to prevent it. I feel like I'm preaching to the choir because I know you as community managers go through this all the time as well. But once the problem exists and we have to come in and fix it, it definitely takes more time and effort on everyone's part, and you're going to incur more legal fees for us to come in and figure out how to fix it and then have to negotiate. And if there's an attorney on the other side, that's when you really start bleeding those legal fees, because now there's all this back and forth between the two attorneys, and that's never going to be quick, right? Because it's not like I'm going to send a letter saying, hey, look, you're wrong, we're right, and you need to just tell your client that. The other attorney isn't going to come back and say, yeah, I'll tell my client they're wrong. That's not going to happen. We're going to have all this back and forth, and it's going to keep going until we either reach some sort of a settlement in which both parties give up something, or the association has to pay something, or there's a court action. Either way, leading up to that, there's going to be a lot of legal fees that the association is going to have to pay for something that I would suspect was probably preventable from the get-go. So don't try to save money by skimping on a legal opinion, because most of the time that's really going to prevent more money being spent afterwards. And finally, trying to save money by doing it yourself. What I'm really talking about, there's a lot of things that fall under this, but for me, what's near and dear to my heart that I'm seeing more and more of are document amendments. I am seeing quite a few folks trying to save money and doing their own document rewrites or amendments. We have an attorney on the board, and they're going to do this, and we'll just let you review it. There has yet to be a time when this happened where an association actually saved money, because, as you all know, our industry is getting more and more regulated. Nothing is getting easier in our world. And every year we're getting more and more requirements dumped on HOAs with respect to almost everything we do. Any attorney that is not a specific HOA practitioner, they don't know all the nuances or all the ins and outs. They just don't, because they don't specialize in it. And they're not going to know how to comply with those. And they're not going to understand how associations function or best practices or anything like that. So ultimately, when the document comes to us, we are still rewriting it in the end. And instead of just writing it from scratch, we are now editing it, which really takes a lot longer. And the associations, as a result, are spending a lot more money for us to do that, which honestly doesn't benefit anyone. You might think it benefits us, but it doesn't, because I'm sitting there pulling hair out of my head trying to edit this thing, and all it does is drive me crazy. So don't assume that I'm like so happy to have these things because I get to bill for them. That's not the case. All right. So I want you to read about this person. It's so funny and sad at the same time. And then I'll go to questions. Okay. All righty. We do have a few legal questions. Questions. When does it make sense to change legal representation? Well, that is a loaded question. I mean, it's really going to be the board's decision. My typical take on it is, if you don't trust your attorney, you're not comfortable with your attorney, you feel the urge to, when they give you advice, you feel the urge to go to someone else and double check their opinion, it's probably time to change, because that means you don't have the requisite trust or belief in them that you need to have like a trusted advisor relationship. If you look at them and you have the feeling you want to punch them in the stomach, also probably a good time to change legal counsel. It's your gut. You know, I mean, your board will know if they're not comfortable with their representative, I guess. What if an owner calls you and states they are a board member? I can talk about it in our case. So if somebody calls us, we actually have a really, really good directory of all the board members. And if someone isn't in our directory, if they call us and they say they're a board member, I am typically going to be reaching out to a manager saying, hey, we got a call from this individual saying they're on the board. Are they on the board? Or if there's no manager, I will call another board member who's in the system and say, hey, is this person really on the board? So we will typically try to do our due diligence to make sure that the person we are talking to is on the board. My association continually enters into poorly written contracts without legal review. Is there any education offered to HOA board members to explain contracts and their importance? That's a great question. And, you know, we've done webinars on contracts. And if you actually go to our YouTube channel, you could probably find a webinar, one of our webinars from last year, a couple of years ago, on contracts, where we talk about important contract provisions. We also have articles on our website under education and resources and things like that, that are also talk about important contract provisions that you are welcome to send out to your board members for review and reading. All right, sorry. Sorry, I am just trying to look through all these. When an individual owner forces the board/management to seek legal counsel, i.e. threatens lawsuit for something silly, can those charges be billed back to the owner? Generally, no. That's typically considered like the cost of doing business. And it is basically the association getting informed as to the legal issues at hand. and therefore it's not something you're going to be able to charge back to that homeowner. Now, if it turns out the homeowner is doing something very wrong in this case, or it turns out to be some sort of an enforcement thing in the end, then certainly we can seek attorney's fees if we end up in court. And if we get awarded them, then, then we can collect them at that point, but otherwise, no. When do you have a dancing chicken or dancing pig as your bride? Why do you have a I've always had them. I've had them for years. And I have them because I like them and they make the world better. All right. We are a self-managed HOA and fee conscious. If we want to ask a question by email but don't know whom to ask, should we email the legal assistant first or send the email to the attorney and the legal assistant? Well, if you are working with our office, you can always send it to the attorney, and if that's not the correct person, then that attorney is going to forward it to the correct attorney. You're not going to get charged for that attorney to forward it to the correct attorney. If you're not with our office and you're with a different law firm, I can't speak to how they do it. So I would probably reach out, like call and ask, like call the main line and ask them how you should do it. Do attorneys have a preference as to point of contact from an association, board members or GM? Is there a best practice for this? Honestly, no. My personal take on this is I'm here to make your life easier. So you tell me what works best for you. For you as the manager, for you as the board, you tell me who you want me to communicate with and how, and I will do whatever you need me to do so that your life is easier. You're not here to make my life easier. It's the opposite of that. So just let me know. And there's no best practices. It's really what works for each individual client. If an owner asks for attorney contact information, is it okay to say that they are not authorized to incur legal expenses on behalf of the HOA and that we can't share that information and to send their inquiry directly to the board? That is absolutely appropriate. Attorneys, if we ever have a homeowner reaching out to us, I'm going to have my legal assistant call them back and say, I'm sorry, we can't incur legal fees. We can't talk to you without board authorization. We encourage you to reach out to the board. That is exactly what's going to happen. You would not incur a fee from us for something like that. That is absolutely correct. Does a previous board decision for a person to talk to legal on behalf of the board carry over to future boards when that chosen person is no longer on the board? Well, I would just recommend then if there's a new board that the new board, if that person is gone, that the new board inform the attorney who the contact is so that that attorney knows who they can talk to and not talk to. Sometimes boards are okay with anyone on the board being able to reach out to the attorney. That's not always great because sometimes, what happens is you got different board members reaching out to the attorney with exactly the same question, and you're getting charged every time someone calls. And so it's typically better to have like one person who is doing that. But again, it's certainly up to each board to make that determination. I would say probably 95% of the time what I see, this isn't necessarily best practices, but what I see is that the community manager is the one who reaches out to the attorney because that's really what they're, one of the things they're getting paid to do. And the boards have, other things they're doing. They have regular jobs and they just don't have time to deal with it. So that's what happens. But again, it's whatever works best for each specific board. That was the last question that I saw. Does anyone else have any questions before we end this? Because otherwise you guys get 5 minutes early. All right. Well, again, if you have time to do the quick survey, I would sure appreciate it. Thank you so much for joining me today, and we will see you guys at the next fun-filled webinar. Thank you.